The Economic Development Committee meeting. Thank you all for being here. 8 o'clock. Senator Burns, would you open us up? What number is that, 3?
You'll join me, please. Father God, we're grateful. We're richly blessed and highly favored and given the honor of serving the people of Georgia. Give us your guidance and wisdom, and may we do your will. In Christ's name I pray. Amen.
Thank you. We've got 3 bills. We're going to do a hearing on Senator Jackson's bill, Senate Bill 251, LC 600083, Fair Business Practice Act of 1975. It's yours.
Thank you, Mr. Chairman. Today I'll be presenting on SB 251, that's LC 600083. I can walk you through the bill, but let me just give you an overall premise around it first so you understand where we're coming from. We have found that renters or people who want to rent a place will see an advertised listing for the rental unit. Let's just for ease say they rent it. It's being advertised as being rented for $1,000. So they go through the process, they get accepted, they move in, and then all of a sudden when it's actually time to pay their rent, they're hit with all of these fees that were not necessarily clearly disclosed. So we anticipate and expect if you have a pet, there's going to be a pet fee, right? Like that. We're not talking about that kind of fee. We're talking about administrative fees, processing fees for paying your rent when the landlord insists that you have to use a particular third-party payer in order to pay, and then there's a surcharge on top of that. Then there's processing fees, there's administrative fees, there's a fee for trash that wasn't disclosed very clearly on the front end, and so your rent suddenly goes from being $1,000 to going to being $1,250, and it surprises people. And a $250 increase in rent can make you not be able to pay it, right? So this bill really, it just says, listen, we acknowledge that fees will happen, but we need those to be disclosed in a conspicuous manner so that people up front understand what those are, but also if it's something that's mandatory that you actually have to live on the property, say for instance trash fee, then it needs to be included in the rent. So if the trash fee is $50 a month, the rent needs to be $1,050, because the reality is you cannot live on that property and not pay a trash fee, right? Like it is required, so it's actually a part of the rent. And so that's what this bill seeks to do, is to just bring some clarity so that folks aren't being caught off guard and being hit with these fees that are essentially junk fees, right? I mean, what is an administrative fee? I don't actually know. And if you have administration fees that you need to recoup, then put it in the price of the rent, right? Like nobody should be shocked and surprised by a sudden administrative fee that was not fully disclosed in the front and that doesn't have any rhyme or reason for why it exists. With that, I'm happy to take questions.
Any questions? Hold on, I'm trying to figure this out here. Oh, there it goes. All right. What number?
Number 10.
10? Okay.
Thank you, Mr. Chairman. Senator Udisi, thanks for bringing this bill. I want to raise the issue of market distortions that I have heard about relative to the pricing of apartments and the availability of single home units. So something I've been made aware of in the last year or two is there have been a lot of apartments that open up that will do promotional pricing on rent, and that will actually draw interest away in the market from potential purchasers of homes. And I know that, we talk about trying to incentivize homeownership as a goal. Can you speak a little bit about the way that this bill might interact with distortionary pricing for apartments that pull people out of that market?
Yeah, sure. I appreciate that. So if you're a person who's looking for a permanent place to live or a semi-permanent, you're looking for a residence, right? You're going to do some basic back of the napkin math of what can I afford? And you can do that and say, oh, well, I could afford a mortgage at this rate, maybe. But if you look in their advertisements that are popping up, because your phone is listening and it knows you're looking for a place to live, right? So if there are all these advertisements that are popping up for an apartment that says, oh, you know, rent is $850, where you're looking at the back of your napkin, you're saying, I couldn't necessarily, my mortgage would be more than that, so this is $850, and so I'll just stay in an apartment for another year while I save up more money, right? Only to move into that apartment and learn that promotional was only for the first month or the first 2 months, and then that actually that rent was way more than you had anticipated or you signed up for in the first place. So it is a distraction, I think, from people reaching that ultimate American goal, but it's also just not accurate. This is why this is in the Fairness in Business Act, right? We want fairness. We want practices that are clear for the ordinary person. We are in the business of reading the fine print here in this legislature. That's what we do. We read fine print. But people should not have to read all the way through 50-page contract to see all of these little fees. Those just need to be conspicuously listed.
Okay. Any other questions? Senator Mallow?
Number 9. Thank you, Mr. Chairman. Madam Whip, just a quick question for you. Last year, actually, this is a situation that happened. We had a couple hurricanes come through the coast, and a couple of my tenants were without power for about 2 weeks. And they thought they had renter's insurance because the apartment complex said you have to get our renter's insurance, only for them to find out their renter's insurance didn't cover the inside of the apartment. It only covered the structure. And so I said, well, it sounds like you're paying the insurance for the property, and they're calling it renter's insurance. Would this bill address that to maybe make it clear what type of insurance they're actually providing to residents and what that would be?
Yeah, thank you. It's a great example. We don't get that granular in these details, but we do have this line that says any other fees that the Attorney General deems to be junk fees. So that may be something that the Attorney General would need to explore. Again, we're not prescriptive to that level. This is much more broad and just in terms of saying, like, you need to be clear and conspicuous about what is happening. And I would argue that certainly would be a conversation that we should have with the Attorney General. People, when they see renter's fees, they assume that it's for their place that they're renting inside. And again, I would actually argue that providing insurance for the outside is actually a part of the requirement of the landlord, not the tenant. The tenant is required for the inside. And so there probably is an argument for how we could fit this under, but the Attorney General would probably need to be involved.
Okay.
Thank you, Mr. Chairman, and thank you, Senator, for bringing this bill. Can you just kind of expound a little bit on the type of disclosures that would be required?
Yes. So if you look through here, let me just see here. I don't have my exact line number here, but the language that we use is clearly, if you look at line 21, it's clearly and conspicuously is the definition that we use, and it needs to be easily noticeable and easily understandable by an ordinary consumer. That displays a total rent price more prominently than other pricing. So, what I'm imagining is, you get, actually Airbnb does a great job of this. Airbnb, it advertises, I happen to have a place that I post on Airbnb, right? So we say it's $199 a night. And then as you go through the contractual process, on that final page, before you say yes, it says, the rent is $199, and then it has the cleaning fee that's not in bold, right? And it has the transaction fee that's not bolded, and then it has the total that's in bold, clearly conspicuous. And it tells you what each one of those things is. Anybody knows what a cleanup fee is. That's very clear, right? So that's what we're talking about, clear and conspicuous, something that anybody who can read can understand, and that's the kind of disclosure we're asking for here.
So you're anticipating that this information would have to be made available on a rental contract?
That's correct. So
Is
before
there a penalty in your bill for not including it?
we don't have any sticks here. I guess the sticks are whatever are involved in the law. Obviously, you'd be open to civil action at some point if you did not comply with these things. But we don't explicitly name here that this is an actionable offense or anything like that. But it certainly is an invitation to put into the law, and when you don't follow the law, you can take action, right?
Follow up, Mr. There's large organizations and corporations that rent houses. They have places where tenants can congregate. Is it enough for them to post those disclosures on the door, or is this something that has to be written in their contract?
So this is specific to renting the place where you're going to be sleeping, right? Where you're going to be residential. So help me.
I'm just thinking about
just talk through that.
all of the large apartment complexes that have all kind of gaming rooms and exercise rooms and a head office. If they posted somewhere on the door in their head office, would that comply with this?
No, it needs to be in the rental agreement, right? So that's here. It needs to be in the rental agreement. This is the agreement. Here are the fees associated with living here. Again, if there's a trash fee, I mean, I'm gonna give y'all some more examples. There are places here in Atlanta where you have to pay a fee to get your mail because they use a third party to sort that mail and to sort the packages. The reality is you can't actually live in a place and not get mail, right? That is a fee that's outside, but in fact, it's something you need. It's necessary. So we would argue that that should be included in the rental price. Again, trash is another one. You cannot live in a place and not have trash service. Like it's not optional, right? So that should be included in the rental fee, not extraneous to that, right? So it's those kinds of fees. We want those to be included in the rental fee, and then for other fees, like a pet fee, it just needs to be conspicuously noted. There's a pet fee for a dog over 50 pounds, it's this amount, or whatever. It just needs to be in the rental agreement, clear and conspicuous, so that folks know what they're signing up for when they sign that lease.
Okay. Oh, you got one more question? All right.
It's more of a comment, Mr. Chairman, unfortunately. But just for some context, I mean, and I've litigated the smallest amount Fair Business Practice Act type style case. You can already, as a consumer, bring an action and say, I think whatever this business is doing is unfair. That's already Georgia law, and then somebody else decides, like a jury or whatever. What we often do in code is we go enumerate specific examples of what we have come across in practice to be unfair, just to give consumers and their attorneys a little guidance in being specific about what direction we want to point it in. So I think one way to think about how useful this type of bill is it's the only way to legislate on fair business and consumer protections is for the legislature to go do exactly what the senator just did and identify specific problems we're seeing in the field. Specific problems we're seeing in the field, and then sort of append them to the statute so that we have clarity and guidance about the type of behavior we're trying to target.
All right, any other Senator Burns?
Mr. Chairman, thank you to the whip for bringing the legislation. Let me be sure I clearly understand. This does not limit the rental amount. Is that true?
That's correct. We're not at all limiting. We're just asking you to disclose fully what it is.
Nor would it limit the fee structure. Is that correct?
That's correct. It does not limit it either.
So your bill is specifically oriented toward disclosing total cost of living in that particular area. Is that right?
That's correct. I will make it with a caveat. Junk fees, so just things that you cannot explain for, those would be considered illegal, right? You can't just add a random $50 administration fee without naming what that is, right?
And junk fee,
Yeah.
is that defined in your code?
It is actually defined.
Could you point that out for me, please?
I don't use the term junk fee. I use the term deceptive fee.
All right, so you use the term deceptive fee.
Right.
Thank you.
Yes.
Well, deceptive fees have a number of subsets, right?
That's right.
I just wanted to make sure we weren't going down a path that would lead us to
We're not capping
limiting
rent
an
fees.
owner's decision about what their property value might be.
No, sir. We are in no way impacting what a landlord. In fact, we're just asking the landlord to be introspective and be up front and clear from the very beginning about how much rent actually costs, right? So saying definitively, you're right, I'm going to make you pay $50 for mail service every month, so we need to disclose that. We're going to put that in the rental fee so that nobody is. But it's also, I think it helps on the front end for anybody who is looking at an apartment, because then the person who can't afford that fee, because it's listed up front, won't waste money applying with an application, because applications these days can cost you $150. And so that consumer gets to save $150 when they realize that the rent isn't actually $850. Once you add all those fees in, the rent is actually more like $1150, and that's beyond their budget.
Thank you.
What's that one?
One, yes, sir. Okay, when we're talking about this, it sounds like what you're describing is if I want to rent an apartment for 6 months or a year to live in, but on lines 47 through 49, we're also now hitting hotels, inns, vacation rentals, and other short-term rentals, which would be, I'm staying in a hotel for 3 nights. Everything's got to be listed. So this is just capturing everything, trying to make sure that it's in there. So
That's correct.
so
And-
we're saying residential property could be a 2-night stay at a hotel.
That's correct. And to be clear, places like that already do that, right? If you go
Yeah.
stay at a hotel, you're going to get a portfolio that's already going to outline, right? So we're actually just asking everybody to come in compliance. What we already see, these rental, like we see hotels doing this really well. We see something like Airbnb. They already do this well. We're just asking landlords to be just as clear and just as explicit as a place would be like a hotel.
Okay. All right, we're going to go to the public. We've got 4 people signed up, I believe. David Wheaton, if you'd like to come up, go to the podium. And Madam Whip, if you'll stay there, because we'll get you to follow up afterwards. Okay. Yes, sir.
All right. Good morning, Chair and members of the committee. My name is David Wheaton. I'm an attorney with the NAACP Legal Defense Fund, founded by Thurgood Marshall. LDF is the nation's premier racial justice, civil rights legal organization. LDF supports Senate Bill 251, which would eliminate junk fees for renters. Rental junk fees have harmful effects on most renter households, but disproportionately harm the lowest income and most marginalized renters, including black renters. The fees are often hidden, random, and arbitrary, and hinder renters' ability to access stable and affordable housing. LDF asked for a favorable report out of committee. So junk fees can add up to hundreds of dollars per month for renters. The White House's Council of Economic Advisors estimated that junk fees alone cost Americans about $276 million a year. In Cobb County, Georgia, fees push one renter's monthly rent from about $1,295 to almost as high as $1,500, which included a monthly fee for pest control services that actually never materialized. Landlords' failure to provide accurate pricing information can threaten a renter's ability to effectively budget and stay in their homes. For people with extremely low incomes, junk fees can quickly add up and strain family savings and create a barrier to housing access. Furthermore, if a tenant ultimately cannot afford to pay the unavoidable junk fees, the fees may become a non-payment of rental debt, and the alleged rental debt can haunt a renter long after they have vacated the housing unit, whether they left because of an eviction case or voluntarily moved out. While steep junk fees compound the heavy burden already placed on rental households, black households bear a particularly heavy burden. As a result of decades of discrimination in housing, lending, and employment in other areas, black people in Georgia are disproportionately likely to be renters and more likely to face evictions and other forms of housing instability. In 2020, more than 50% of the black households in Georgia, or just under 1.9 million black Georgia residents, lived in rental housings. Because black renters cannot afford to pay these additional fees, as noted by the Brookings Institute, a lot of black workers are low-wage workers. So in Macon, 64% of the low-wage workers are black. In Savannah, 50% of the low-wage workers are black. Rental debt due to junk fees also disproportionately affects renters of color. According to the National Equity Alliance, 66% of people with rental debt are people of color. And so in closing, Senate Bill 251 is just a much-needed step to improve transparency and promote fairness. Every renter should know the true cost of finding and staying in their home, and the fees charged to renters should be fair and transparent. Thank you.
Mr. Chairman, if I
Burns.
could, I have a question for the presenter. You started your remarks by saying eliminate junk fees. Is that correct?
Yes, or not fully eliminate, but at least
You-
be
you
fair,
started with the
transparent.
premise that this would eliminate junk fees. Is that correct?
Yes.
All right, then I'd like to ask the author, is that the intent of your bill?
So it will eliminate anything that's not being provided. So the example that he gave, which was somebody paying for pest control that never manifested, like that would become illegal. That's actually illegal now.
It's illegal now.
Right, but-
We would agree.
Right, but
Does
we-
your bill eliminate fees?
No, it does not eliminate fees in any way, shape, or form. It just makes you have to be clear and transparent about those fees.
Thank you. I appreciate the clarification.
Yeah.
Okay, thank you. Matthew, is Matthew here? Matthew Nursery? And then Anton, you're up after him. Be ready. Thanks.
Hello, thank you, committee. My name is Matthew Nursey. I am an organizer and a policy advocate with Housing Justice League based here in Atlanta, but we do coalition work all across the state with tenants all over Georgia. This bill is about transparency and consumer protection. All Georgians deserve to know what fees to expect on their bills at the time of signing their lease. Whether you live in rural Georgia, the suburbs, or the city, inflation is high, wages are low, and junk fees add to the monthly and even weekly budgeting that working people do. When one enters a contract, it is expected that both parties live up to that contract. To add frivolous and arbitrary junk fees is a breach of contract and assault on the pursuance of the American dream. Recently, the House side signed a bill, voted on a bill that provides more transparency for consumers when they go to eat shrimp in Georgia. This bill is similar in my mind. It just says that this is what you are paying for, and this is exactly what is going to be in the lease expected when you pay rent. So it's just about transparency and giving the consumer and the tenant upfront knowing what they're going to be paying. Passing this bill out of committee would signify that the Georgia Senate stands with the consumers and renters of Georgia. And I want to thank Senator Jackson for bringing this bill, and also Senator Goodman for signing as a co-sponsor. And we definitely ask that this bill comes out of committee favorably. Thank you.
Thank you. All right. Anton Tran, you're next.
Hi, thank you for having me. My name's Anton Tran. I can begin, right?
Yeah.
I'm a PhD candidate at Georgia Tech, where I study housing data, and rental junk fees are something that I've come across in my research and are heavily affecting Americans and Georgians today. Junk fees, those deceptive charges that corporations use to rip off consumers at the end of a transaction. A study by the American Economic Liberties Project finds and estimates that an average family of 4 loses more than $3,200 a year annually to junk fees, and much more whenever they make a significant purchase or rent a home. We also know that Atlanta specifically is ground zero for corporate landlord activity. And corporate landlords are the actors that tend to charge junk fees. And when I say corporate landlord, I'm referring to institutional investors, private equity. Specifically overcharging for things like pest control or services like valet trash, where trash is not actually picked up and someone can simply take their trash to the dumpster themselves. These are the types of fees that are becoming more and more prevalent, and these types of fees heavily affect people who are already marginalized by housing. When renters apply and must pay an application fee, they also have to go through a background check. Doing this repeatedly can really affect things like their credit score. And they have already paid the application fee, which can be already cost prohibitive for low-income families, and then they feel like they have to take this rental housing because they cannot afford to pay a $150 application fee that's not conspicuous to 5 or 6 other places. I'm also a student, so I understand what it's like when you need to find housing, and looking for housing is like a full-time job. You're applying to multiple places, you're paying multiple application fees, you're getting your background check screened, and these are all things that generate data that ultimately harms you, and you're so far into the price and the cost at that point that you feel like you have to rent an apartment that you frankly cannot afford to live in because of all of the excessive fees on top of that. And when you consider the percentage of those fees to, if you're renting, if it's $3,200 and you're paying $1,000 a month, and the average is $3,200 a year that you lose to junk fees, that's $250 a month. That's like almost a quarter on top of what you think you can pay. So I highly urge you to consider this bill to make all of these fees conspicuous, and also consider about the after effects beyond just the financial repercussions.
All right. Thank you. Latresa Cheney, are you here for this bill? All right.
Good morning. Yes, I am Latricia Cheney. I am a tenant organizer as well as an eviction defense advocate with Housing Justice League. Matthew is my coworker. I'm going to reiterate mostly what everybody is saying, but I'm going to give you an example. I'm also a renter of Decatur, Georgia. When I was searching for housing, this particular excuse me, this particular complex was advertising that a 2-bedroom, 2-bath was going to be, my rent is going to be $1,100. And I would have if I came in for a particular time, I would get a month's free. I was like, oh God, there's nowhere in Atlanta you can live with a 2-bedroom and 2-bath for $1,100. That's a great deal. Plus you get a month for rent. This is the advertisement, and it's called the Slate of Decatur. So as I go, I speak with the management company, the management. So she stated that, okay, I have a $75 application fee. I have a $500 background to run my background, my credit check, and if I pass that, then I would not have to pay that was the deposit. It's between $500 and $1,000. So, okay, that was the closed. So I was like, well, I mean, I've been working on my credit for about 2 years, and so just so I could become a homeowner. But I know that I was not, as an advocate for a nonprofit organization, I'm only bringing home $2,200 a month. So, okay, I pay the application fee and I pay the administrative fee because I passed the credit check in the background. Okay, here comes the lease. So I have $1,100, for rent. I have $75 for water and sewer. I have $100 for trash. to take my trash and put it in the dumpster, which is overloaded because it has the capacity of the apartments outweigh the dumpster. So I'm dealing with pet fees as well. I had disputed that because I'm like, I don't have a pet, so why should I pay pet fees? And I had to go through the third degree to even get that $50. It's when I tell you, I feel like if you stand in an apartment complex, let me just start with that. It's mandatory that these companies have to keep their property clean anyway, right? And we're also, as tenants, you should not be charged to pay the management for cleaning the property. Let me say that. And I mean, I'm saying about the trash fees. That should be anyway. Now, the water and the sewer, the reason why I brought that up was because on the news, it was stating that Decatur is raising their water and sewer every year. So this year it is $70, but the complex is charging anywhere from $75 to $100 on the water. And you shouldn't have to pay water bill in an apartment complex because we got hundreds of people that are using this same water line. So how can you divide? You mean to tell me that you're putting 300 meters on 300 units? It can't be. It can't be. So how can you distinguish how much water 300 people in a complex use every month? This is every month. So to say that is that my rent is the base pay when I'm signing the lease is $1,100, but with the fees of water, pet fee, trash, and the insurance, That's another thing. Like you said, it only covers the structure of
I need you to wrap up.
Okay. It only covers the structure of the outside of the property, not, so you have to pay that on top of your own insurance to cover your property. Okay, so I'm at $13.25 from 1,100, and all those junk fees does not apply to me. So I should not have to pay. Thank you.
All right, we've got one last speaker, Hayden Stanley.
Good morning. Thank you, Mr. Chairman, members of the committee, Senator Jackson. My name is Hayden Stanley. I represent the Georgia Apartment Association. And I will agree with the premise of the four people who spoke before me, and that is fees and the rent should be disclosed prior to the execution of a contract. The practice for the members of the Georgia Apartment Association, which are the great majority of the apartment communities in Georgia, is to disclose fees, rent, and all costs associated with the rental in a welcome letter, and then each of those are included in the lease available for review prior to signing. In terms of this legislation, however, we've heard, and I appreciate Senator Burns' questions, we've heard a variety of fees that in some cases should not be imposed, again, according to those who came before me. So while we don't argue with the premise that fees and costs should be disclosed and both parties know exactly what they're getting into with a lease agreement, we do believe that this bill provides for more than simply disclosure. And for that reason, Senator Jackson, we've had a great working relationship through the years, and we've arrived at very good law as a result of that. And we pledge to continue to have a conversation around disclosure of fees, and would ask to spend the interim working on this matter.
All right. Senator McLaurin? Okay.
Thanks, Mr. Chairman. Thank you. Good to see Mr. Stanley, as always. I would agree with you that the list from 24 to 34 includes more. Can you hear me on this, by the way? Okay. Includes.
Yeah, it's on.
It's on 10. Okay, great. Includes more than just terms that are omitted from a lease. I mean, but one of the things that we're hearing, and that, I mean, I've had personal experience with as a renter in Sandy Springs for when I was in the State House, sometimes you pay for a fee and it may be provided for in the lease, and the apartment does such a bad job of delivering on the service that they might as well not be providing the service. Would you at least acknowledge that in that case there's a case to be made for using the Fair Business Practices Act? Because again, if you're approaching it from a withholding rent or landlord-tenant rights or contract perspective, that is such much more involved argumentation in order to try to make your case. You can't, I mean, the idea of a tenant bringing a breach of contract case on a, $40 trash valet charge or something like that seems a little rich. So I guess my question would be, do you not at least acknowledge there's a case to be made for having some protection if it is identified in the lease, but the service is substandard or not provided at all?
I would think that is embedded in the lease, that you're paying a fee for a service and the service is not provided. That would be a breach.
Okay, so
I don't disagree generally.
But the official position in the apartments is you have a breach of contract action that you can bring in that case, I guess.
Yes.
Okay.
Senator Anderson?
Thank you, Mr. Chairman. What part of the bill do you disagree with? You said generally you agree, but what part specifically do you disagree with?
My point is that this bill has it's written, as everyone's acknowledged, very broadly. There's some the analysis that I received from Attorney Mike Williams, who represents the Apartment Association, seems to believe that because of the definition of deceptive fees, that there are fees that would be prohibited because of the broad language included in the bill. So again, we don't disagree that fees and rent and cost should be disclosed prior to the entrance of an agreement. We do believe that the language within the bill could be better refined, and we'll work on that.
I guess I'm asking what part that needs to be refined. So you and I both know that I have 12 years in housing in a low-income subsidized property that was not Section 8, but that people had to have an income to even qualify to live in. So I did it for 12 years. We both know. I know Mike Williams, love Mike Williams, attorney. What part of this you're saying is, I'm asking specifically what part of this don't you,
If I can, let me grab the bill.
I may be able to help too.
no. Okay.
Yeah, please. So a couple of things. First of all, we've discussed, everyone that's testified today has talked about a variety of different bills. There's most recently a conversation around water, paying additional and separately for water. During the Purdue administration, this legislature passed a law which required every new apartment property built after the year it was passed to be sub-metered, so that residents can pay or must pay for their own water. And the purpose for that, of course, was part of the water wars and to encourage water conservation. So that's an example of something that apparently some citizens believe this bill addresses, and the sponsor does not. So there's clarification that needs to happen through this. Secondly, this bill prohibits the use, as I understand it, the use of a specific vendor for that property to the exclusion of a resident using their own. Often you have a bulk agreement on internet and cable, as I understand it, and that generates a cost to the resident which is far lower than they would be able to get on their own. So if this bill, because of that line, could conceivably make that an illegal fee or an illegal arrangement, then that's something that is far away different than disclosure of fees at the beginning of a lease. So those are the types of issues that we think we need to work through.
Okay.
Thank you for the question.
Ms. Stanley, will you work with Ms. Jackson,
Absolutely.
Minority Whip Jackson, to tighten this up?
Yes, Mr. Chairman,
Because I actually think, we're doing a hearing only today on this bill, but I actually like a lot of what she's talking about. So we
Yes, sir.
need to tighten this thing up and make sure that there's bad actors out there. We need to take care of that, but not hurt the good actors, and see how we can get something done for her on this.
We'll
If
certainly
we have to call a
continue the
special meeting
conversation as
between
we
now and
always.
Monday, we will. It's 2-year biennial, so we'll get to it, but I do like a lot of what she's talking about.
I appreciate that and appreciate the opportunity to work with you through the
All right.
interim on this.
Okay, thank you.
Thanks.
All right, we're going to
Thank you,
go to Senate Bill 107 and 108, and we've already heard, you can stay right there, but just bring the mic up to you. We've already talked about these two bills. At the last meeting, I asked Senator Summers and Chairman Summers and Senator McLaurin to work with you, and I believe they've made a lot of changes. I was out yesterday, I was out of town, but I'm going to turn it over, before I turn it over to you, Senator James, I'm going to turn it over to Senator McLaurin, and if you would, tell us what we've got here.
Sure, Mr. Chairman, happy to do it. Taking Senator James's great work product and, at the will of the committee, beefing it a little bit, taking it to the gym, getting some reps in. And so if I could point everybody to page 5 of the sub. You've got a sub for SB 107 in your folder. That's LC 550573S. So page 5 of the bill has a part 2 that starts on line 96. As you'll see, the code section 443270, we went ahead and added a subsection A there just to break it up, and a new B. Yeah. So if you see lines 108 to 110, there's a new B subsection, and that B subsection says that an association, neither an association nor current HOA board member or former HOA board member may acquire a property at foreclosure. Because, there's a lot of, and we've heard feedback from the public that that is an issue, that there's sort of an inside game with respect to getting units at foreclosure. So we added that in. We changed the $2,000 line that was, or limit that was previously at 101, 102 for the lien. We changed that to a variable amount that's tied to 12 months of assessments. So depending on the community you're in, they have got different HOA fees. Rather than it being a flat 2,000, it's just 12 times whatever the monthly HOA assessment would be. So that's obviously going to be a number that ranges above 2,000, which is a stronger protection for the owner than was in the original bill.
Thank you.
Sure. And then we made one other change in 107, which was on page 6 at the very top, line 115, and the provision sort of goes between the pages from the bottom of page 5 to the top of page 6. What it said before, well, basically what this provision has to do with is if you are an owner and you lose your property to foreclosure, you have what's called a right of redemption, that within the first however much period of time, if you're able to get the money together to make all your accounts past due good, then you can actually get your property back. So what it does is it restricts, in the current version of the bill that we had before this committee day, would have restricted the amount of time that the foreclosure buyer cannot transfer the property away. It was at 4 months, meaning that they've got to wait on the property to give you the opportunity to give you the right to redeem in case you're able to do it. We've taken that limit from 4 months to 6 months. So that means you now have 6 months to get together what you need after a foreclosure and buy your property back in the event that you're able to do that. That's SB 107, and obviously SB 107 is primarily focused on the foreclosure process and the liens. SB 108 is more about the, go ahead, yeah.
Can I just ask a question about
Yeah.
line 108?
Uh-huh.
It says, "No community association that brings the foreclosure action against the lien in the unit in favor of the community association." Then
Yeah.
it lists a number of things. Will you consider adding not just the community association, but no other entity associated with that association? Because corporations that own houses
Sure.
typically will own multiple entities.
Sure, so that would be a friendly amendment to add an affiliate of the community association. So either a parent, subsidiary, or other affiliate, I think would be a
Yes.
good, okay, we can add that in just a minute.
Okay, let's vote on the bill first.
Okay.
Senator Hodges.
Quick question here. And I know we discussed this ad nauseum last time, but a couple of points. I love the right of redemption. It's great. But are we going a little bit too far here? I mean, we're worrying about the bad actors, and I think we're doing it to the detriment of the other homeowners or condo owners. Couple of reasons, couple of things. Number one, the 12 months, does that just allow somebody to not pay for 12 months?
It would mean that before a
But
foreclosure.
if I wanted to, I could just sit there and not pay for 12 months and then pay, and you couldn't touch me.
In a foreclosure process.
Right.
I think there are still, you could accumulate potentially fines. I know the foreclosure can't be initiated on the fines under this bill, but there's fines potentially. My understanding is also that based on what happens with the companion legislation, if there's a dispute resolution process, that might be initiated with the owner. And so you go after could mean one of a number of different things. And as you know, we hear this a lot in the legal system, the process is punishment. And so even tying up a person or an owner in a dispute resolution process in advance of foreclosure, and again, I'm no HOA expert, I just sort of found this rule yesterday.
And secondly, again, I think we're legislating for bad actors only here, because if I live in a condo complex and somebody can't keep it and it's going to be foreclosed, the community of interest of the owners is the best place to have somebody to buy it. or the entire community might want to buy it. And I think again, I understand why, some bad actors might be trying to, but we're legislating to a point where you're cutting out everybody else, and that's kind of draconian to me.
Okay. Senator Mallow?
Thank you, Mr. Chairman. I just want to provide clarity. When you lose your property for the failure to pay, for example, county taxes, county or city taxes, your home is sold on the courthouse steps, and it's not to any particular person within your neighborhood. It is sold on the courthouse steps to whoever will buy it at the auction price. One of the other things to also consider is when you have a failure to pay property taxes, there is still a 12-month right for redemption to the actual property owner to pay the tax commissioner to satisfy and get the property back before it goes through the quiet title action of the borrower's right to redemption being cleared, and then also clearing out that new person is responsible from buying it for also all the liens that may exist on the property if they buy it from the courthouse steps. So while I think this, in my opinion, the 6 months, because it's a condo, gives great flexibility, but if you're a homeowner and you lose your house at the courthouse steps, you don't get, the time frame is much longer, actually. And I think for me, the juxtaposition comes when you talk about services that the county or city may provide. That's your police, fire, EMS, essential services. Condo association, I'm thinking of, pool, common area maintenance, those kind of things, giving people an opportunity to pay that before you foreclose on them. I think that's a better prescription than you just can foreclose on me and I don't have a right to redemption to get that back.
I didn't say anything about the right of redemption. I think that's a wonderful idea, absolutely wonderful idea. My problem is with not allowing people in the community to buy at foreclosure, and also making sure that there's something so somebody just doesn't sit and not pay for 12 months. Those are the two things that I have problems with the bill.
All right.
Okay.
Excuse me.
Senator Jones, do you have a question or a comment?
Yes,
I do, and I disagree because this deals with condo associations. So even if someone was behind and didn't pay, we're trying to prevent the association from taking advantage of those that's under their care, not someone who may particularly lose their house, as the senator from the second has already said. There's other actions that homeowner would be facing. This only deals with the association and their predatory nature. That's all.
Okay, before we entertain a motion, we have two people signed up for 107 or 108. Ann McKill, please. Hold it 2 minutes if you would. Go on up.
Right here.
You're at the podium. And then after that, we've got Beth Taylor. You're on deck.
I spoke yesterday, but just want to, and I spoke with Senator McLaurin about you can have commercial units in a building, and so instead of just referring to it as a residential community, somehow change that so that it's all members of the association. And the other thing I have a problem with is the word complaint. We actually had one, and I can show you on my phone, we have one owner that sends 2 emails every day with complaints. So we need to make that be real complaints, not just arbitrary. And I brought up the one about the board can't buy it back, or a member of the association. Our board, I wasn't on the board at this time, but our board actually one time said they were going to raise, we had a problem tenant, their fees and fines enough that they couldn't pay it. And the president of the board said, I will buy this property. So that's what they do, and that's why I suggest that you have in there that because the board controls the fine amounts. So they can raise it to whatever. But I understand the position that you're withholding somebody's right to buy property.
Thank you. Beth Taylor, please.
Good morning. My name is Beth Taylor. I'm a community association attorney and have been for over 20 years. And are here on behalf of CAI Georgia. And we have some concerns about Senate Bills 107 and 108. Speaking to the issues of judicial foreclosure, there is a grave concern about this focusing on the bad actors to the detriment of the good actors, as we've heard some similar concerns. There is already protections in place for the Condominium Act and POA Act for judicial foreclosure now. In order for a Condo Act or POA Act to foreclose, there has to be a court order authorizing judicial foreclosure. So the community association has to go through the judicial process, get a court order, have a judge weigh in and rule on the reasonableness of the amounts being sought, whether they're assessments or fines, and then also expressly give the remedy of judicial foreclosure. So there's already protections in place. It's not like a tax sale or a lender foreclosure sale where the HOAs can rush to the courthouse steps without judicial intervention. And so that's already in place to protect. And this is a lengthy process. It doesn't happen overnight. It has to go through the court system. And then once the judge enters that order, there's a whole second process in place because the judicial foreclosures are facilitated by the individual county sheriff's office. So it's not a 6-month process, it's a 12-month, 2-year process. So there are already protections in place when it comes to judicial foreclosure. And judicial foreclosure is also a remedy that the associations use when you have this abandoned property. When you have this property that's been paid in full, left, abandoned for years, is an eyesore to the community. And then secondly, I know my time is short, the concerns are, again, good actors will be punished. To facilitate the ADR processes and some of the other processes set forth in these two bills, it's going to essentially be and result in practically an increase in assessments across the board for all homeowners. In order to go through the ombudsman process, to go through the ADR process, the associations are going to have to use their management companies, use their attorneys, go to third parties, because these boards are volunteers. And so at the end of the day, all the people who pay are going to pay more, and those who don't are still not going to.
Okay, thank you.
Thank you.
You got a question for her? All right.
My question is, the process you just described is what this bill is trying to avoid. Homeowners association members that are already bound to fees don't have the necessary resources to challenge and fight the different issues that you all have filed against them in the court of law. That's why you're so successful on doing that. What we're trying to do is prevent the association from taking advantage of a homeowner who's already in distress. So I believe, Mr. Chairman, that the process you just described gives me more of a reason why I want to support this legislation.
Thank you, Mr. Chairman.
Mello.
Real quick question for you. When the property is gone through the judicial foreclosure process, is it not true that all the fees that once the property is then sold is returned back to the association and the individual does not receive anything if the property is sold in excess?
Is my understanding that if there are excess funds from the sale that are in excess of the association's judgment, then there's often down the road an interpleader case, or there can also be the sheriff will give notice to all interested owners, or excuse me, all interested stakeholders that there's excess proceeds, and then claims can be made.
They don't do whether they should.
Okay.
I'm sorry.
Look.
But it's my bill, so.
All right.
Okay.
Thank you for your testimony.
Thank you.
All right, here's what we're going to do. First off, I want to thank Senator James for all your hard work for study committees and what you've put into this. I want to thank Senator McLaurin and Senator Summers for helping you make this bill even better and stronger. I also want to thank Megan and Ella they got the committee sub, I think, this morning. And so thank you for all y'all's hard work. So here's what I want to do. I want to entertain a motion. So I'm
so
ready.
Move, Mr. Chairman, on.
It's SB 107 LC 55057-3S.
That is correct, Mr. Chairman. So moved.
Oh, got it.
And I've got an amendment.
Okay, we're gonna first. We got that. Now we'll take an amendment.
I'll move the Senator Jones amendment. This would be line 109. After the words "nor any," I would propose to add the words subsidiary, comma, parent, comma, affiliate, comma, or any.
Okay, you got that? Okay. All right. Do I have a second on that friendly amendment?
Second.
Second. So what we'll do is we'll vote on the amendment first, and then we'll vote on the bill as amended. All in favor of the amendment, please raise your hand. Okay. Against? Okay, it's unanimous. Now we're going to vote on the overall Bill 107 as amended. All in favor, raise your hand. Okay, all against? All right, it's unanimous. Two. Oh, you voted against? Oh, two against?
Yeah.
Two against? All right. So the bill passes. Thank you. Now we're going to move on to 108, and I'm going to go to Senator McLaurin on this also.
Sure. So this bill covers the alternative dispute resolution, or ADR, procedures that would be adopted. I have worked with the senators to add two things. After, I want to make sure we have the right LC number here. This is
LC 550574S.
Oh, yeah, I'm looking the wrong one, sorry. I was trying to find it.
Yeah, it's LC 550574S.
That's exactly right. Okay, I've got the right copy now. Okay. So, well, this is supposed to have, all right, I thought that this had a 5 and a 6 to it. I can add them on the fly, Mr. Chairman, because honestly I remember what they are, but this copy may not have, unfortunately, may have come out of the office without 5 and 6. Basically, I'll describe what the intention was. The intention was to add a good faith requirement for the association's negotiation, and the most important aspect of the good faith requirement would be timeliness, basically not delaying proceedings unreasonably. And so we had a number, basically if you go to the bottom of page 3, you see that starting on line 57, the dispute resolution procedure has to include certain features. So we were going to add a subparagraph 5 that says they have to act in good faith and with reasonable speed. And then there's going to be a subparagraph 6 that would be an enforcement for that, which is fee shifting provision to allow an owner to seek attorney's fees in the event that the association violates the good faith provision.
That makes it.
So anyway, that's some teeth. And again, this was supposed to come out of the oven with those already included, but I can move those amendments on the fly if you'd like, Mr. Chairman.
All right, well, what we'll do then is, are you ready to make an amendment after I've?
100%.
All right. Because I want to take action on this also. I'll entertain a motion on SB 108, LC 550574S.
So moved.
Okay, got a motion?
Oh, yeah.
And a second from Senator Anderson. And then you'd like to make some amendments?
I'll make an amendment, and everybody bear with me here because I'm just going to read from my phone. After line 65, to insert a subparagraph 5 that says, the association must act in good faith in all matters relating to the procedure, comma, including, comma, but not limited to, making reasonable efforts to engage in and conclude the proceeding promptly, period. So that's 5, and then the subparagraph 6 to be added would be
What line's that?
so after 65, we're in a nebulous space that exists only in your mind after line 65. And then the subparagraph 6 to be added would be any association that violates subparagraph 5 shall be liable for reasonable attorney's fees. Period.
Okay. All right.
Discussion, Mr. Chairman.
So we've got, first I've got to get it, before we have discussion on these amendments, I got to get a motion and a second.
So that's the motion. The motion is now made.
All right.
And there needs to be a
Second.
Second?
Okay.
All right, now we'll do discussion on the amendment.
I'd just like for the senator from the 14th to go over subparagraph 5 again. I get
Yeah.
the part about
Yeah.
acted in good faith. I get that. I don't get all of the other afterwards. If we could just kind of
Yeah, so
explain that again, please.
what
Why it's needed.
I'm hearing is that if an association or an owner starts an ADR process, that one sort of informal tool at the association's disposal is delay. That if the owner wants to have their rights declared, and make sure that they're protected against a foreclosure action, and if the association drags its feet or does not reasonably promptly comply with the procedure, then that can leave the owner in limbo. And this is a requirement that would apply to the association to engage in good faith. And that could include any aspect of the negotiation, but the one that we would call out in the code would be the promptness of it, the speed of it.
I understand the good faith, but the wording that you had after that just seems to be problematic to me because you're weakening the good faith by including that additional language. That's what it sounded to me. Can you read it again, please?
Yeah, I don't think it actually weakens it. I think by calling it out, it might make it stronger. But okay, so including but not limited to making reasonable efforts to engage in and conclude the procedure promptly. So promptly meaning with reasonable speed, basically.
Okay. Senator Summers? Chairman Summers?
Yeah, I got
don't
you.
think it's necessary.
Okay.
Senator McLaurin, subparagraph 6 in regards to, I'm a simple old country boy.
Yeah.
What is reasonable attorney fees?
Yeah, so that means if you're in any, but that's throughout the code. I mean, the code contracts, that phrase reasonable attorney's fees is just stock language, and what it refers to, I'll be happy to entertain any questions about it. What it basically refers to is that if you're in a judicial proceeding where you are awarding fees, whether it's the judge or a jury that awards litigation expenses or fees, that they get to decide. It has to be it can't be excessive. If it's got to be cabined within a reasonable amount, or else it could get reversed by an appellate court, that sort of thing.
Okay. Hold on one second before you
Yeah.
ask a question. I'm going to ask our legislative counsel has a comment.
Yes, I'm sorry. I just
Go ahead.
wanted to note this before it potentially gets too far afield, and I apologize if I'm mistaken about this, but Senator McLaurin, is it not the case that in the additions to subsection, we have subsection F in the new bill, in the substitute.
Yeah.
Does that not?
Is it already in there?
I believe so. I think the provisions that you're discussing
Okay.
in amendments 5 and 6.
Yeah. That's right.
Starting at line 71, correct?
That's right. It's already in there, and the problem is I had asked for it to be somewhere else, so I got confused, and so I think I just got a draft that this is all happening last night and this morning. So
We did this early this morning.
Yeah,
Or
yeah.
late last night.
So thank you for that catch. I'm going to withdraw my amendment because it's already in the sub.
Okay.
Yeah.
All right. So the amendment's withdrawn. Senator Burns?
Thank you. Like Senator Summers, I come from a dirt road in South Georgia, and but the biggest heartburn I have about the adjustments is the liability for attorney fees. Is this common in typical language?
So fee shifting in general is a provision to add some oomph to any bill, and it is completely the election of the majority where to add that oomph. I mean, I can give you countless examples from legislating the last 6 years. We had a monuments bill. If you remove a monument, there's attorney's fees, trouble damages, all that. It's one of many tools to make sure that somebody really complies with something. And the other thing is, if you presume that the association has better access to counsel than the owner does on average, which would probably be the case, a fee shifting provision is also a way to balance the access to counsel, because if you think you're going to get your attorney's fees as a recovery, you are better able to sign up counsel on the front end than just paying out of pocket hourly for an attorney and hoping for the best.
Thank you. Still have a little heartburn.
All right. Sure. Senator Anderson, do you have a?
I'm good.
Oh, so now
Senator,
the posture.
Melody.
Oh, you've got, all right.
It's on page
To my
4.
to my friend from Southeast Georgia, I think in Southeast Georgia you may have we don't have as many silk stocking lawyers like in Atlanta, so I see this as an opportunity for an incentive for some of our general practice attorneys to want to take your case and not charge as much, knowing that they could recover it on the back end for taking the case.
Okay. All right. You got a question?
does the reverse of that apply also? If you look at lines 49, 50, and 51. Association shall adopt a written policy providing for a fair, reasonable, and expeditious alternative dispute resolution procedure for resolving any dispute regarding sums assessed by the association. We put a new roof on the condo. Somebody doesn't want to pay for it. Boom. I'm gonna dispute it. So then I dragged the condominium association around for 6 months disputing it. I mean, can the association get their attorney's fees back at that?
The way it's written right now, the attorney's fees provision applies only to the owner recovering. If
Yeah.
it's the will of the committee, you can make that
Well,
provision
I
bilateral.
worry about any dispute. I mean, nobody wants to spend money, but if you're gonna own property, it's gonna cost you. And
To be clear, the fee shifting, the way it's written, only happens if the association is found not to have acted in good faith. So if the association acts in good faith, no attorney fee shifting.
That should be.
Okay.
I mean, where does it say that?
So basically, the way it's constructed, and I apologize that I didn't see that it was later in the bill, but on lines 71 through 78 of the sub is the new language. So 71 through 74 is
right, wait a minute.
paragraph, 71 through 74 is paragraph 1, and that says
Oh, I got you.
the association has to act in good faith. So then the way 75 through 78 is written is if an association
What-
violates the provisions.
What
of
about a
paragraph-
member?
Say that again?
What about a member? Member have to act in good faith also?
Okay, if you want to make it bilateral, we can.
That's great.
Okay,
If
I
you do
can-
that, I think it's perfect.
Then I'll move an amendment
Okay.
once we have
All
it.
right.
Yeah.
All right.
Well, actually, we're on a due pass posture, I guess. so-
We're on a due pass posture.
Okay. So I'll-
Let me
yeah.
tell you where we're at here.
That's fine.
We've got a motion, due pass on the
Correct.
overall bill.
Underlying bill.
You withdrew your amendment
I can make another
because
one.
of 71 through 78,
That's right.
I guess,
That's right.
after legal counsel pointed that out.
Yep.
Now you'd like to make a friendly amendment, another
Yes,
amendment?
yes.
Okay, I'll entertain an amendment.
Okay, so from 71 to 72, line 71, 72, we strike an association and put in its place the parties. So that's the first part of the amendment. And then in line
Party should be good.
75 to 76, actually, first of all, yeah, this is the second part of the amendment. An association on line 76 is replaced with any party. And then the end of line 76, the lot owner, should be replaced with, here's a fancy one, the aggrieved party. How about
Okay.
that?
You got that? Okay.
All right. There you go.
I've got a motion. Do I have a second?
Second.
Second from Senator Mallow. Any discussion on the amendment? All right, we're going to vote on the amendment. All in favor say, raise your hand. All right, it passes. Your no? Okay, one no, but it passes.
Open it.
All right, now we're going to vote on the overall bill as amended by Senator McLaurin. Any discussion on that? All right, we've already got that. So let's take the vote. Everybody in favor? As amended, raise your hand. Okay. All opposed? You got one opposed. Thank you very much. And again, I want to thank Senator James for all your hard work. I want to thank Senator McLaurin. Thank you for all your hard work, and Senator Summers. That's all we have. We're adjourned. Thank you.